call that case. Case number 115628, estate of Roxy A. Moore v. Maureen E. Miles et al.
May it please the court. My name is Jason Brewer and I represent the appellant Harvey Moore Jr. I respectfully request 6 minutes for rebuttal time.
6 minutes is granted.
Thank you. This matter is before the court because of a transfer on death deed signed by an attorney-in-fact which conveyed the family farm of Roxy Moore to the attorney-in-fact, Maureen Miles. Roxy lived to be 100 years old. Roxy and her husband had one child, the appellant, Harvey Moore Jr. Harvey Jr. was married to the appellee, Maureen Miles, and they had two sons, Bart and Ryan. They would later divorce. In 1991, Roxy suffered a stroke that impacted her frontal lobe and greatly impacted her ability to speak. From 1991 to 2003, Roxy stayed in her own home with Harvey looking after her. In 2003, Roxy's condition worsened and she required the care of a nursing home. At that time of Roxy's nursing home stay, she had a most severe combination of vascular dementia and Alzheimer's dementia, which rendered her disoriented and confused. On April 29, 2004, at age 94 years, Roxy signed a general durable power of attorney, naming her former daughter-in-law, Maureen Miles, as her attorney-in-fact. 11 days later, on May 10, 2004, Maureen signed a transfer on death deed as the durable power of attorney for Roxy Moore. There was a notary there that acknowledged the signature of Maureen in her representative capacity as durable power of attorney for Roxy. The power of attorney and deed were delivered to Maureen Miles' attorney, who had also prepared the transfer on death deed. Her attorney wrote a letter to the Register of Deeds office directing that the power of attorney instrument be recorded at least 1 minute prior to recording of the transfer on death deed. In September 2009, Roxy passed away. At the time of Roxy's death, the farm vested in the name of Maureen Miles. Harvey filed suit. The district court granted summary judgment in favor of Harvey on the theory that Ms. Miles did not have authority under the power of attorney. Maureen then disclaimed acting under that authority as a power of attorney and instead said she was a mere non-thinking amanuensis. After trial, judgment was granted in Ms. Miles' favor. On behalf of Harvey Moore Jr., I have two requests that we would like to make to this court on this day. Number one, we would ask that this court reject the execution of a transfer on death deed by an amanuensis and void this deed. Number two, we would request that where there is an instrument executed under the purported authority of a power of attorney, that this court adopt a bright line rule prohibiting the introduction of extrinsic evidence of oral directives of the principal that would serve the purpose of expanding the power and scope of a written power of attorney to make gifts to the attorney-in-fact, or to disclaim acting under that authority. Those are our two requests this morning.
Let me clarify that second one. You want us to reject the notion that the durable power of attorney could be expanded to self-gifting orally?
That's correct.
And reject the notion that you could, if you purport to sign, that can be orally rejected.
Based upon some type of outside oral directive, that's correct. As to the first requests that we have made to avoid this transfer on death deed. We believe this to be a matter purely of statutory interpretation. This was addressed in issue number 1 of the supplemental brief, and I think if we were trying to determine what was the legislative intent behind the transfer on death deed, would it permit signing by an amanuensis? I think the best evidence that it does not provide for that are a comparison of 5 statutes that we have in Kansas, all dealing with the execution of instruments. Those 5 statutes are as follows. KSA 59-3501, which is a transfer on death deed statute.
Well, let me back up here. I mean, here there's what if a person, are you saying that a person is precluded from a transfer on death deed if they're incapable of signing their signature? I mean, physically incapable? I thought that the trial court in his memorandum decision made a good point. Stephen Hawking couldn't transfer on death or a person who's incapable of physically signing a document.
That is our position, and more importantly, I believe that to be the position of the legislature.
Okay, so a person who is physically incapable cannot utilize this particular statute to transfer his or her property if they're physically incapable of writing.
That is correct.
Okay, so
Well,
that's your
they couldn't.
Well, wait a minute. That's your blanket point here, and where do you get that? Why can't that person who has the intellectual capability of saying, "I want you to sign this for me"? We've recognized. I was not familiar with the term amanuensis until this case. I'll be quite frank, but apparently it does have a pretty rich history, not only in this state but in every state in the union, regarding the ability for someone in that position to allow someone to sign for them if that's their wish and is capable of doing that. But in this instance, you can't do it.
Well, I think there's 2 things involved there. First of all, since there are so few formalities in the execution of a transfer on death deed, there's very little out there to prevent actual fraud. And so, but what we have here is the legislature, under the Power of Attorney Act, KSA 58-652, subsection A3, they made a distinction prior to 2009, under the Power of Attorney Act. It had to be signed by the principal, dated, and acknowledged. And that was it. In 2009, the legislature went back to that particular act, and they included this. If the principal is physically unable to sign the power of attorney, but otherwise competent and conscious, the power of attorney may be signed by an adult designee of the principal in the presence of the principal and at the specific direction of the principal, expressed in the presence of a notary public.
Okay, Counselor, let's take that back to the question. So Stephen Hawking could, under a Kansas statute, execute a power of attorney that would have allowed that attorney in fact to gift to themselves if it had expressed that in the power of attorney.
To give to themselves, but not through the instrumentality of a transfer on death deed.
Why layer it? Why have to go through a 2-document process to get to the same end?
Well, it's because there's so little to protect against fraud. If you look at the will statute would appear to allow something like an amanuensis under a will. But with a will, you have some prohibitions. First of all, the person that's drafting the will, if they're a non-family member, they can't inherit under that will unless there's an independent attorney. If they're a family member drafting the will, they can't inherit more than they would have had they inherited under the laws of intestate succession. Furthermore, under a will, you have 2 disinterested witnesses. And so you have these, and under trust, you don't have the 2 disinterested witnesses, but you do have the earlier prohibitions that I talked about under the wills, as far as the drafter of the trust can also be the sole beneficiary of that trust.
Would you real quickly give me the other 4 statute numbers?
Yes, Your Honor,
You have 593501.
which is a transfer on death
And
deed
I'm-
statute.
I'm assuming that you're getting into 59605 and those others, when you're talking about the Scrivener inheriting. And 605 says, a witness, a provision signed by a witness who then, inherits under that. If they're a non-relative, that voids that provision. So are all of those the ones you're talking about? Just give me the numbers.
Right, I'll give you the
Start-
numbers.
Okay.
Transfer on death deed 59-3501, the deed statute 58-2205, the will statute 59-606, the do not resuscitate order or DNR statute 65-4943, and the power of attorney statute, which I just quoted, KSA 58-652, and the applicable provisions are subsection A3.
Why don't you include 582209? 582209 indicates that it applies to all deeds or other conveyances of lands or of any interest or estate therein shall be subscribed by the party granting the same or by the party's lawful agent or attorney. That's a directive. All deeds that are transferring real estate are subject to that. And in order to get to the amanuensis, we have to read that as including not only the agent or the attorney, but also the amanuensis.
I think, Justice Johnson, that would clarify deeds under KSA 58-2205. My argument would be one of specific over general. And so the transfer on death deed statute in KSA 59 is distinct and separate.
So
and further-
you're saying the TOD does not fit within the statutory statement, all deeds or other conveyances of land.
I think that it's because even though the legislature has said it's a non-testamentary for this purpose,
Precisely.
it's testamentary in nature because it does not go into effect. The conveyance is there, but it doesn't vest in the grantee until.
Well, I know how it operates, but it is a deed and it's called a deed and it's specifically statutorily called not a testamentary instrument. And if you want to construe imperi materia, then 2209 that says all deeds, I don't see how you say the TOD falls outside that, since the legislature itself has used that word and refuted it being a testamentary instrument.
Right, and I think the legislature created this. It's a legislative creation, the transfer on death deed statute. It was enacted after the deed statutes. It wasn't enacted until 1997. And so before that, we had the old pocket deeds where basically we'd execute a deed, and then you had these predictable problems of, has there been a delivery of that deed where we think they intended to actually make a testamentary disposition, or not? Did they change their mind? And so I think it's a creature of statute, and that the legislature has shown an intent here that they could have put the same language in the transfer on death deed statute that they did just recently in 2009 with the power of attorney statute, but they did not. And so I'm not really willing, under expressio unius est exclusio alterius, the expression of one thing is the exclusion of another in that statute when it comes to execution. I think if the legislature intended this, they could have done just like what they did with the Power of Attorney Act.
Again, your focus on really the issue at hand is that your theory is that amanuensis cannot be utilized in this type of scenario, and your concern is the potential for fraud.
Yes. Under amanuensis, the exception becomes the rule, because every time a person acts under a proper power of attorney, but they act outside the scope of the power of attorney, they're always going to allege the principal told me to. And under the durability provisions of a power of attorney, it passes beyond the capacity of the principal. So the capacity of the principal, if they're incapacitated under a durable power of attorney, the durable power of attorney is still good, unlike before when we had non-durable powers of attorney. So they have no ability to revoke that or change that. It's beyond that. Getting to your question about the concern about can a person like a Stephen Hawking, why can they not avail themselves to that? I would like to address that.
Okay,
but you can go ahead and address your
my
question.
question is, didn't the trial court, when it comes to the potential for fraud, do everything that is required to alleviate that concern? There was a hearing, an extensive hearing with many, many witnesses, both that Harvey presented and that Maureen presented, regarding not only undue influence, but testamentary capacity. All of that was and the burdens were, I think, properly placed there. And then when the amanuensis benefits from the transaction, deemed it presumed invalid, but provided a rebuttable presumption, and then overcame that presumption. That's three pretty high hurdles, I would think, that would address the fraud concern, and the court addressed those. So what else could happen here? I mean, what else should be done other than to say it's just plainly can't happen?
Well, first of all, the district court improperly looked at the mental capacity that Harvey would have to disprove. So Harvey had to disprove that Roxy Moore had incapacity necessary to execute what is a transfer on death deed. And even though the legislature has said this is a non-testamentary transaction, instead of using a deed and contractual standard, which is a preponderance of the evidence, instead he used a testamentary standard, which is clear and convincing, to come to the conclusion that Harvey failed to prove mental incapacity. The problem with that is we have Fish v. Poorman, which says it's a preponderance of the evidence when you're dealing with incapacity of a deed. And I think this makes perfect sense. When you're lacking so many testamentary formalities in a transfer on death deed, I can see why we would have a lower standard than you would under a will that's presumed to be valid. The other issue is the undue influence. To rebut the theory of undue influence, this was the first time that I'd seen this in Kansas, where we had to rebut this, and it was successfully rebutted at trial. The problem with that is the standard by which you have to rebut undue influence, once it's found, once you have the two-pronged test there in Cresto, that standard should be clear and convincing evidence. And my basis for alleging that standard is that we have the estate of Koch, which is the appellate court opinion that affirmed a district court's finding of undue influence was rebutted by clear and convincing evidence. And so we have other cases. There's a state of Clark out of Pennsylvania that also says clear and convincing evidence. So once Harvey has met this very difficult burden of undue influence, there were 8 factors the court looked at to conclude undue influence. And it's always going to be more difficult for the challenger because the challenger's never in that room. The person in that room can always allege, they told me to. And how do you rebut something like that? So once we've met this very high, clear and convincing standard, then it doesn't make sense to go back to a standard like you would have under a directed verdict, which is what the appellate court used to say, there's a requirement under a directed verdict to resolve all inferences in favor of the party against whom the directed verdict is sought.
There is a mechanism through the statute whereby that is supposed to be proved. Who said what and how things were done, and that's the notary. That we require these to be acknowledged. Mm-hmm. And if they're not acknowledged, you have to go to court and get a certification if the acknowledgment's missing. Here we have an acknowledgement. We're not missing a scenario in which, they said, he said, whatever. We have an acknowledgement, and that acknowledgement says that the deed was executed by an attorney in fact.
Yes.
So
And-
when
and-
you said that there's no way to challenge that because, you know, there was no one there, well, there is a legally designated person that's charged with the responsibility to acknowledge the true and correct execution of the instrument.
Right, and without that acknowledgement, it could not be recorded without further proof as required by KSA 58-2229. So if we take an acknowledgement that says this was signed by Maureen Miles in her capacity as an attorney in fact, and then say, no, I'm disclaiming that I didn't sign under that, I signed under some other express oral authority, then we've defeated the whole purpose behind the acknowledgement. Because the notary has to determine, is this person that's in front of me signing this, are they the person they say they are? And then they have to determine if they're signing this in a representative capacity, we have to show they're signing it with proper authority.
And just to clarify, the testimony at the hearing was that Ms. Newlick, the notary in this case, had no independent recollection of who said what to whom?
That is correct. She's the notary that worked for the attorney that drafted the transfer on death deed. And you're correct. She
She's
had
the
no knowledge.
acknowledgement on the document.
But
Correct.
she did not have independent recollection some 11 years later. That's correct.
Counsel, I see we've taken a lot of your time with our questions. Would you like 30 seconds to wrap up before you come back on rebuttal? Or you want to wait till then?
Well, I'll say just a few more things. First of all, what we're asking for under the second thing there, this bright line rule, I would point out that other courts have done that in South Carolina, Hawaii, Wisconsin, South Dakota, and Maryland, also in Missouri. And so what we're requesting there is not something that hasn't been done before.
And explain that bright line rule.
Well, the bright line rule, what you're trying to do there is...
No, just
Sure.
state the rule. What is the rule?
The rule is that when there is a valid power of attorney, the attorney in fact cannot self-gift using oral authorities outside the scope of that power of attorney.
So you can't amend a durable power of attorney orally to self-deal.
To self-deal
Okay.
or to disclaim acting under the power of attorney later on.
Thank you, counsel.
May it please the court, James Oliver for the Appellees. This is not the argument I expected to hear. I expected that maybe the reason why this case came up on a petition for review was Judge Atchison's concurring opinion, and that was the issue that they would talk about. What should be the standard for proving undue influence, and whether that is really in the case. Instead, they're back on these bright line rules that I believe have been thoroughly disposed of by the Court of Appeals opinion and
But
by
can't we
other
review
cases.
those? Can't we review those?
No, but I
Can't we
believe
grant
I just
that?
believe they're correct. You can review those.
Well, then let me get you, before you get into what you want to say, what do you think about 582209?
I think 582209 applies to all deeds like it says.
Okay, and if it does apply to the deed before us, we have to read that statute as including, in addition to the agent, lawful agent or attorney that it describes, to include an amanuensis.
I don't think that's really the process of construction, because what the cases say is that a signature by an amanuensis is the signature of the owner. That it operates as a matter of law with the same effect. Wait, as the person signing themselves.
But the telling tale here to me, Counselor, is that this says shall be subscribed by the party granting the same.
Mm-hmm.
And it doesn't say executed. Some of the other statutes we're talking about says executed. It says subscribed. And if you look up the definition of subscription, it is to write one's name underneath.
Mm-hmm.
And so that seems to be more definite as to the intent is you write your own name. And there's to sign with one's own hand in token of consent or obligation. And so you're saying that subscribe, sign with one's own hand is satisfied if you tell someone else to sign for you.
Yes. I mean, this happens in my life. My father is 94 years old and in a nursing home, and he is very bright, but has a palsy. And once in a while you can get him to sign his signature, but most often he'll say, sign it for me.
I assume your argument would essentially be that there's no difference between the person with palsy pushing the button on the auto pen or what I mean, it's...
Yeah, it gets subscribed at their direction and by the best means they can use. And the law has long recognized that. And these principles about amanuensis, of course, were used when people didn't know how to write.
But why are we talking public policy and practicality when we have, this is a creature statute. When I started practicing, there wasn't any TODs.
Mm-hmm.
You know, it's totally and so we're not applying common law to the common law of transfer on death deeds because they're a creature statute. And if they're a creature statute, we construe the statutes that apply. And public policy or any of that is not applicable to our process, is it?
But I mean, I still go back to when you construe the statutes, you are looking at historically what people believed and understood those terms to mean and what was permissible, and that you're saying that the statutes intended to repeal what everybody would normally think in common organization, in common society, should be allowed, and it isn't. And I believe that if you're construing the statute to mean that, that would be inadvertent. It wasn't intended to repeal the law of allowing people to sign by the hand of another. That's long been recognized and is recognized as subscribing.
But you agree with me that we need to construe that. You're just arguing that we have to construe subscribed by the party granting the same to include an amanuensis.
Yes.
That's what you're saying.
That
and
is
so then we
included in
apply the canons, if there's some ambiguity, if that creates an ambiguity because there's common law about that, then we apply canons of construction, don't we? And one of those is if the legislature knows how to say something and they don't, that's a telling tale. And your opposing counsel said the legislature knew how to talk about another signing for someone incapable in the Power of Attorney Act, but they didn't put that in 58 or 59, did they? You understand what I'm saying? Is that we have to construe these statutes the way we construe these statutes.
Well, I guess you do, but I don't see that is an implied or intended repeal by the legislature of the long-standing interpretation of the law to allow a person to sign by the hand of another and have it operate in law as the effect of their own signature. And that's what historic Kansas cases say. It has that effect. Same as if they signed it.
Do we have a case in Kansas that used the theory of amanuensis with regard to any deed transferring real estate?
I believe so. I can't remember. There are two old cases that recognize the validity of the doctrine, and I can't remember if they were deed cases.
Were they, well, I'd have to look at the genesis of 2209.
But what
Because 2209 is not, I mean, it deals specifically with all deeds or other conveyances of lands or other estate or interest therein. And so we have specifically dealing with, if you're gonna transfer land, here's what has to happen.
and so does
And so, you're applying a general concept, from before the turn of the last century that, I've never seen applied in my 38 years in law, and certainly never seen applied to the transfer of real estate.
that may be because most people don't contest those. I think it, and you know, you have to. The fact that there isn't a case doesn't mean that it's wrong or that it's not allowed. It has generally been allowed.
Is your position that subscribed by the party has a plain meaning and it's apparent on the face of the statute, or that it's ambiguous and that we should look to these other sources to construe it in the way that you suggest we construe it?
I mean, when you read literally what the doctrine of amanuensis says in the Kansas cases, it says the signature by another is the signature of the person directing that signature to be effect and operates with
So
the same
subscribed
effect
is-
as if they did it, and so it is subscribed by that person.
Plain
when it is
language,
signed.
not
That's
ambiguous.
What it means.
That's your
Yeah.
Okay.
And that's been the law of deeds. That's subscribing, that concept, execution, however you say it. Generally, it means the same thing. And in common understanding, you can affix a signature by the hand of another. Now, I just want to talk about briefly what the public policy involved is in these kinds of transactions and how that applies in real society. Maureen found herself in the role of caring for her ex-mother-in-law, not because she sought that role, but because it was thrust upon her by circumstances. You've read the briefs and you know what Harvey Jr. did. He lost half of their real estate holdings by pledging it or mortgaging it for his debts and not paying them back. He was given $80,000 during his lifetime. He spent it, lost that. He had numerous lawsuits against him, and after Roxy had her stroke in 1991, he testified that he never had a meaningful conversation with her thereafter, and she lived another 18 years. Never had a meaningful conversation with her.
Is this a legal question or an equitable question?
This, what?
The question before the court is are we talking about equities? Who should get this land?
No, I'm
Or are we
talking about
the legalities?
what the public policy. I'm going to talk about what the public policy should be and why the law should be what it is.
But the public policy is what the legislature says it is.
On-
That's what
on
we've said that
signature-
numerous times, that the public policy in the areas of law in which the statutory law has developed is determined by the legislative acts, not by this court. Have we not?
Yes.
Okay, so we're back to where we are before.
Okay, so I'm back on considering any common law issues in this case. What should the public policy be on what you pronounce the law to be, and what you should do to protect
and what
the
you're-
elderly and infirm?
Right, and what you're talking about in protecting the elderly and the infirmed is the question is it, does it even matter if Harvey was in your mind maybe not deserving, or there's a reason why he would have been not the beneficiary of the land, and let's say the grandkids were not should not be the beneficiaries for their conduct. Does it matter? Roxy's wishes are what's important,
paramount,
right? And it's
yes.
not. It doesn't
And that's
matter
not
what
in doubt.
the equities don't matter.
No, what I'm getting at in terms of if you're really getting into undue influence analysis, and as I understand it, we're really not. that we're looking at this case as just a pure interpretation of a statute.
Right.
But when you look at what do we do? We're trying to protect the elderly from the depredations of the people most likely to take advantage of them. And when you say that that's a person in a confidential relationship and it was actually thrust upon them, and how hard should the law be on that person so that you can actually presume that the good person in this story is the bad person
Well-
and put the burden of proof on them?
I'm a little confused. This, when you talk to equities here, my understanding was that Roxy wanted this to go to her grandkids. And so she executed a deed to give to a non-relative, ex-daughter-in-law who was married, whose husband then would acquire an inchoate interest in the real estate. You agree with that? So that if Maureen had walked out of the nursing home, had a will, that reciprocal wills giving to her husband and been hit by a bus, then Maureen's husband would own the real estate. And so I don't understand how we're giving effect to what she wanted to do by the instrument we have here. You understand what I'm saying?
Yeah, I think you're saying the lawyer, she didn't get good advice about how to get this done. Roxy, the problem here is you're going by Roxy's advice. Maureen did not try to do this herself. She did not go to see her own lawyer. She went to the lawyer that she thought Roxy used, and she paid him with Roxy's money to represent Roxy. And Roxy said, do this. And her theory was this will get it to Maureen, and Maureen will take care of the children, whereas Harvey won't.
And we already know, because you've been here before, I think that was the Cresto estate, that what was intended to do doesn't always get done if it wasn't done legally. And that's where we are here. I don't think anyone's questioning what Roxy wanted to do, but we can't decide real estate law based on what may have been in the owner's heart. You talk about protecting people and protecting the elderly and infirm. They are protected by the rules governing the transfer of real estate, that it has to be done in a certain way, it has to be acknowledged, it has to be recorded, all of those rules are in place to protect people, are they not?
Yes,
Okay.
but the rules are in place with the understanding that, for example, a deed doesn't have to be acknowledged to be valid between the parties. And a deed with an acknowledgement the acknowledgement is valid if it's in substantial compliance. If it is recorded in what the deed has to be signed by Roxy, which it was by amanuensis, and it doesn't have to be acknowledged to be valid.
But we're not talking about Roxy and Maureen, who are the two parties, are we?
Well,
And even if it would be even an invalid acknowledgement, you said that it's valid between the parties even without the acknowledgement, but the acknowledgement gives notice to the world, does
Right.
it not? And so we're not talking about the validity between those two, are we?
And we're not talking about a bona fide purchaser either. And there is no estate of Roxy Moore. There was no probate. There was no one offered a will for probate. This was a proceeding to determine descent and distribution on the sole claim that this deed doesn't convey it. There's nobody, no executor, no administrator, nobody standing in Roxy's shoes saying, we think the evidence is the other way and we don't want to do it. And the third party attacking a fully executed parole agreement has a purpose, has a remedy if they can show Roxy didn't want to do this.
I want you to, I don't want to get into what I've used a lot of your time, but I do want you to include some discussion on the fact that, would you agree that a deed has to be signed in some manner?
Yes.
Okay, and we have a signature here in the capacity, written capacity as power of attorney, and we have the acknowledgement the person that's charged with observing and verifying, saying that it was done as an agent. And in order to get your theory of amanuensis, you have to establish that Maureen was not an agent, correct?
No. You could be both.
You can be both an amanuensis and you can sign as an agent and an amanuensis.
Why not? Both are consistent with authority to sign the document. The one,
I thought
the
the case law
power of
that-
attorney would give you power to make discretionary decisions whether to sign it. Amanuensis is a mechanical act,
I thought
and
the,
you could
the
have
case
both
law that
authorities
you,
at the same time.
I thought the case law that you cited that old case law specifically says an amanuensis is not an agent.
Well, that's true. You don't have to be an agent. It's that amanuensis authority doesn't confer discretionary agency.
It's essentially like a mechanical auto pen. That's the one thing that I come back to. That's what your argument is, right?
Yes.
There's no agency here because this is a
It is
mere
a-
scrivener. It's mechanical. Even though it's a biological hand that is
Right.
writing the name.
The cases,
As a matter of law, it's no different at all than a mechanical robot signing the name at the push of a button.
that's the way the cases describe it, as a mechanical act.
Now, explain then how we get around that the document itself indicates the signature was done as an agent, not mechanically, but as an agent, and the notary that took the acknowledgement said that it was signed as an agent. As the attorney in fact, not an agent, an attorney in fact. And that's what we have before us, and that was recorded, and that's our document here. And tell me why we don't have to modify the document with the parole testimony that it was mechanical, it wasn't as subscribed.
I think that goes to one's understanding of what the parole evidence rule does and says. And it is a rule that prohibits contradicting a written instrument in order to change what was done substantively in that instrument, the contract, the deed, the will. And it is always permissible to show, this is a separate, it is not part of the substantive deed that says, I convey to Maureen, transfer on death. You can always show your capacity and your authority to sign separately. That you're not contradicting any substantive term of the agreement. And frankly, the Maureen believed at the time that she presumably had authority under the power of attorney, and she was mistaken. But the fact that she signed for Roxy in the presence of the notary is true. And as the Court of Appeals point out, all the recorder, an acknowledgement has to say to be valid is, this was acknowledged before me, notary public. And the Kansas cases have said substantial compliance is good enough. This was recorded. And I think you can just get, and I get back to why would you interpret the law to be so harsh on an elderly and infirm person that they lose their ability to do things that they can have the intent to do? And I think you can be too suspicious of the good and kind motives of people and whether they're doing anything wrong. And in most cases, my experience is the people that wind up caring for the elderly and doing all the hard things are not fraud-feasers. They're the good guys.
Can we back up to where you started? And
Okay.
that's where you thought we would be here talking about the standard, the burden.
Yes.
And that would be on when an amanuensis benefits from the transaction. It's presumed invalid, and then that creates a rebuttable presumption. And the dissent in the Court of Appeals, I thought articulately stated, in order to address the fraud types of concern, thought a higher standard of clear and convincing ought to be utilized. and why shouldn't it be?
The higher,
If we get to that point. But
Okay, if you get to
if
that
we get
point.
there, why shouldn't the burden in that situation be clear and convincing?
here's, I mean, the law has long been that the burden is on the party alleging undue influence to plead it and to prove it by clear and convincing evidence. Then there is a burden shifting.
Isn't there a problem here when the amanuensis is a beneficiary? Should that just kind of create at least the burden being on Maureen here?
Well, there's two different burdens. I think one is the California case addresses authority to do the manual act of signing. What duress, coercion, Kansas defines undue influence as, and it says in the Ginter case, in a word, coercion. That's what undue influence is. Coercing, imposing duress, fraud, that it gets a person to sign a document they, of their free will, would not sign. It's overcoming their free will. And the mere act of using an amanuensis, saying, I please ask you to sign this document, is a different event. And so they're sort of superimposing in the judge's analysis Kansas law of undue influence, and do you really presume undue influence when there was no evidence? Harvey produced two witnesses, himself and Dr. Call, and the testimony went only to capacity.
Well, you're not disputing that the burden shifted in this case, are you?
The burden to show the validity of that
The
signature, the
bur-
mechanical act of
No,
signing,
I'm-
was on Maureen.
I'm talking about the burden to either prove or disprove undue influence.
I think Kansas cases would say that you only get to disprove undue influence, have to disprove influence, if there's more than just a confidential relationship and a benefit. There must be
Well, the Court of
confidential
Appeals-
relationship, benefit, and suspicious circumstances.
The Court of Appeals held that the burden shifted,
Yes.
and that's not before us, is it? I mean, that holding is not before us to review.
I guess not. I mean,
We're only asking.
It's not right.
Okay, you disagree with it, but
I think we completely get, you get these cases that say very plainly that in cases of undue influence, that fraud is never presumed, and that human desire, motive, opportunity to exercise such influence will not alone authorize the inference that undue influence was in fact exercised. Neither will suspicion nor possibility be enough to justify a finding of undue influence. Then you get the cognitive dissonance by using the term suspicious circumstances to shift the burden. But I don't think the burden shifting is the key issue. The key issue focused on by Judge Atchison is whether the person accused has to overcome the presumption, if you shift, by clear and convincing evidence. And the majority rule in all of the states around us is no.
let me back you up just a little bit.
Kansas is that undue influence, when it's presumed, that is not
So-
a shift of the burden of proof. It's a burden of going
That's
forward
what I
with
wanted to
the
ask
evidence.
about. What's
That's
the
what
difference
happens.
between a shift of burden of proof and a presumption?
I
I think of them as
Well,
essentially
most
the same.
presumptions, we use the word presumption, and this is a common confusion in the law, and very often, most often, I think they say, no, presumption doesn't shift the burden of proof, it shifts the burden of going forward with the evidence. It aids the person alleging undue influence to get to the jury. But once there's evidence to the other side,
Well,
if the evidence
so let me
shows
use
by a
let's use your
preponderance-
words and say, so you it sounds like you're not contesting the fact that these quote unquote suspicious circumstances, the fact that the person who actually signed benefited, created a presumption of undue influence.
I do disagree with that.
Okay.
Benefit and confidential relationship is not enough.
So in
there
your
must
view,
be more. There must be circumstances that would cause one to suspicion that Roxy didn't want to do this, that would allow an inference that she ought to explain why, that maybe there wasn't something wrong here. But it takes more than benefit. It's confidential relationship, benefit, plus additional suspicious circumstances.
Well, if we disagree with you, and if we disagree with that and say, no, the burden has shifted in this instance, and you're just saying it should be preponderance because that's what the rest of the states do around us.
Well, it makes...
It just seems to me that clear and convincing addresses the fraud concerns in a more, maybe not concrete fashion, but it places a higher burden to address the issue of fraud.
And I think that's an unfair burden. No person should be required to prove a negative by clear and convincing evidence. As the person accused of undue influence, and if your response is, what? I didn't do anything. I never twisted her arm. I never encouraged her to do this. I never imposed any duress. There's no evidence that this is anything other than a natural wish, a natural desire of the person who made the conveyance. The burden of proof by clear and convincing evidence is on the proponent of the alleged wrongdoing, and it stays with them. And if it's rebutted so that the judge finds a preponderance that this didn't happen, we don't award judgments against people for things that probably didn't happen. And that's the wrong standard that has been spoken only casually in dicta, citing what district courts said. There are a few cases around the country that follow it. There's a 2015 Nebraska case that says, wait a minute, we've been saying this wrong and we apologize for using the wrong language.
Well,
this is really just a permissible inquiry.
Help me understand what happened at the district court. Was there ever a finding by anyone, by any fact finder, that there were suspicious, at least quote unquote suspicious circumstances that created a presumption of undue influence that needed to be rebutted? Or did the Court of Appeals just talk about that?
No, the judge, the word undue influence first was spoken in closing argument in this case. It wasn't in any pleading, it wasn't an issue, and it's just whatever is inherent in alleging amanuensis.
So even if there is a rule of law that says meeting some standard of evidence creates a presumption, that your argument is that didn't happen in this case. Even if that is a rule of law, there's no record to demonstrate that that actually happened here.
The judge found that there were suspicious circumstances, which I believe was wrong. They're not really
Okay,
suspicious
so that is
in context.
but that is a fact.
But
finding.
if he found that, and then he found that it had been rebutted by a preponderance of the evidence.
Okay, that's
and
what I
their
thought.
argument below was, well, that ought to be clear and convincing. But if it's probably didn't happen, preponderance is the right test.
But
for
you are
rebutting
stuck.
the
You are
presumption.
stuck with those fact findings. Now,
Yes.
what the impact of those fact findings are as a matter of law, you're here to argue about. But the fact findings exist, and you haven't questioned
They exist. Well, we argued, below that this is an appeal from all the issues by the other side, and if you're right for any reason, you win as an appellee, and I can win because these circumstances aren't suspicious. They don't cause one to infer that Roxy was coerced into doing this. They just don't. And what's cited as suspicious creates merely the possibility. Roxy was in a close relationship. Well, I guess she might have done it. But there's no positive evidence that would allow you to question this transaction in any way.
Do we have any further questions?
One quick one. Does it make any difference in applying the theory of amanuensis whether Roxy was directing the signature pursuant to the durable power of attorney or thought she was? You understand what I'm saying? A person has given a power of attorney to their attorney in fact who operates to take care of their business. That's kind of you've got the right to sign, and she says you sign and intending for the attorney in fact to execute. Does that make any difference on the analysis as to whether this is an auto pad poking a button or a mechanical act or an agency act? You understand my question?
I do understand your
Yeah.
question, and it's a new hypothesis about what the facts might have been. I'd say it shouldn't change the analysis, but what happened, a Marine went there with the deed intending that Roxy would sign. It wasn't prepared for her signature by a power of attorney. She didn't intend to exercise discretionary authority.
We understand all that.
She just
That-
inadvertently
we understand,
wrote power
Counselor,
of
we
attorney.
understand the facts. But you understand, I'm saying that, we're talking about a mechanical act or an act of an agent. And we have a finding that the agent's act was ultra vires, beyond the agent's authority, right? And so we have to then determine that if Roxy wanted her agent to sign it, but that wasn't permissible, that then she would have wanted her to sign mechanically as an amanuensis. That's, I mean,
And
we
in
have
the
to.
context, that was what happened. That was Roxy's intent.
And
She
my
said,
understanding-
"Sign it for me."
My
in
understanding
the presence
is
of
that's
6
the
witnesses.
fact. I mean, that was a fact finding below.
Right, that has
also.
been found to be a fact, that was true. Thank you.
Any more questions? Thank you, counsel.
Thank you.
Counsel, let me just jump in and ask you my auto pen question. Does the transfer on death deed statute permit the use of an auto pen? Under your view of the statute?
Under my view of the statute, it would not.
Okay.
And there
And that's
are,
because it requires the, I'll use the word biological act of signing. In other words, hand to paper.
it requires something of that nature. I think that the situation,
Well,
I mean,
what else is of that nature other than
Well-
hand to paper?
right, well, when those few folks that cannot sign, physically cannot sign, they have other legal documents they probably do sign from time to time. And I would imagine they would, a lot of them do that through their mouth. We have artists that use their mouth to actually sign something or make their mark. And so I think.
So a mouth signing is permitted under the statute, but the use of a mechanical auto pen is not permitted.
It's,
That's your
well,
understanding
I'm
of the
not
statute.
sure I'm following you with the mechanical auto pen, like where they press a button,
Yeah,
like with
just,
Stephen Hawking where he presses the button and it does it.
right.
I think that's different. I think that could be his acknowledgement, yes.
And so okay, so if you concede that the use of a mechanical, or I'll just call it a robot, a machine, to effect the signature, what's the difference between that and the mechanical act of the amanuensis?
A couple of things. One is amanuensis, we try to say this is not an agency, but it is a type of agency. We try to say, well, it was just a mere, it was a hand of Roxy kind of thing. But it's a form of agency. It's a form of one person telling another person what to do. Now, we do not have, I think we follow the equal dignities doctrine in Kansas, and the district court judge talked about that in his opinion at summary judgment. But
What if Roxy had laid her hand on top of Maureen's hand while she signed?
I think
Does
that
that-
works.
That works.
I think that works, yes.
And the auto pen is more akin to what I saw in a lot of the abstracts that I examined years ago, where a person would use their mark. People that couldn't write used a mark. And there was a procedure for someone to verify that that was their mark. But it was their act, just like the auto pen is the act. It's not telling someone else to act for them. That's the distinction, isn't it?
I believe it is, and it's not just that, but it's what the role of an attorney is. We see this every day, and we have to understand that Roxy Moore had dementia, Alzheimer's dementia, and she had vascular dementia. And anyone who's cared for somebody like that or dealt with somebody like that understands there are bad days and there are really bad days. And so we're concerned about, did she intend to do this at one point? Well,
Wasn't there was a whole hearing on that aspect of capacity, and that's where at least 10 witnesses appeared to talk about that very issue you're talking about. And
The-
wasn't there a court finding that satisfied the court that she did have the capacity to do this?
The court finding was also one of the suspicious circumstances, rather, on the undue influence. And so the court finding was that she possessed the necessary capacity by a slight degree. And so when the district court flip-flops the burdens, when he makes a higher burden for Harvey to disprove capacity, or incapacity rather, the importance is the time of the signing. And at the time of the signing, we had 3 interested parties in the same room, and we had a notary, and the one party that can't remember, and the one party that was a disinterested party that was available to testify as to what happened that day said she had slurred speech. You had to listen to her real closely. It was kind of hard to hear what she said, but you had to listen to her. This is not a situation where this person had a very strong mind. This is an infirm person, a very aged person, and she is laying on her back in a nursing home, 94 years of age. The nurse's notes indicate a month prior she'd fallen out of bed twice. She had slurred speech. She was drooling out of her mouth. And on the day of the actual signing, she's laying in bed, and her most important property, she can't lift an arm to sign. And if that doesn't overcome the free will of an individual, I don't know what's left. She can't leave. She's at the nursing home. She can't go anywhere else.
Those are all evidentiary questions, right? And you lost on those questions at the district court.
And the
correct?
district, that's correct.
And so how do we get at it? What's our standard of review when you're asking us to either reweigh evidence or what? Remand for a new trial?
Well, as to the evidentiary issues, using the wrong burden, I would say that would have to be remanded. I don't think you can reweigh that evidence at this level.
The concurring opinion at the Court of Appeals said the lower court used the wrong standard, but it doesn't matter in this case because the evidence was pretty overwhelming and even met the higher standard.
That's what he opined, yes. Yeah, the majority obviously said it was a lower standard that she had to meet.
And also said it would be harmless if you used a higher standard. You had all 3 Court of Appeals. Make your best argument why the Court of Appeals got that wrong.
Because we can't go back to the district judge. At that point in time, he's hearing all the evidence, and he thinks it's a preponderance of the evidence, and he's evaluating all the evidence, thinking preponderance, and then go back and say, well, he would have met it by clear and convincing too. That's reweighing the evidence right there. Said, well, if any burden, he would have met it because there was plenty of evidence. Well, that's reweighing the evidence. When the judge makes a finding and says, as one of these suspicious circumstances, that she possessed a necessary capacity by only a slight degree, and then uses a preponderance of the evidence to say, yeah, she had capacity, when it's clear and convincing under a deed and contractual burden, he's burden shifted. And so...
harmless, the notion of harmlessness is not available in this circumstance.
We've
That's
had
your argument.
2 burdens shifted. I'd say it would not be available there, nor would it be under the undue influence factors. And incidentally, in the district court's opinion, there were 8 factors that the court found were suspicious circumstances. So it wasn't like this was just a couple of things. Those 8 factors included that the deed to the grandsons took place during pretrial negotiations 3 years after Roxy passed away. There was a delay in informing Harvey of the transfer on death deed. There was no consideration paid for the farm. Roxy was completely and entirely dependent on others for management of her affairs. Roxy had no independent advice. Maureen obtained the transfer on death deed from her attorney. There was a paperwork delay. Roxy delayed 94 years to do an estate plan at all. And this was it, apparently. And then the last part was her age and infirmity, and she possessed the necessary capacity by only a slight degree. I think that the danger with amanuensis is that, and this happens all the time, counsel was correct, this does happen. I've seen this happen as well. But you have a role of an attorney, and part of the role of the attorney is to evaluate the capacity of the person signing the document to have the attorney explain to them what the consequences of the document are, because that wasn't explained to her. She had no one to explain that to her. And then finally is to make sure that this is the intent of the grantor, not of the grantee, beneficiary on this thing. And so I think that generally it's ripe for fraud. If we allow amanuensis, it will become the rule, not the exception, in any estate plan document.
David Andrews was Roxy's attorney, though.
David Andrews' billing statement was all to Maureen Miles. David Andrews' communications was all with Maureen Miles. There were no communications with Roxy. It was alleged that he was her attorney, but there was no evidence whatsoever, any prior dealings whatsoever. He happened to be the same attorney that was in the same building as the place where Maureen Miles worked.
I wanted to go back to what I understood your argument to be a few minutes ago, and that is because of this purported error made by the district court on the burden of proof, that there was nothing that the Court of Appeal should have done or that we can do. It has to go back. Is
I
that
think if
generally
we-
what you're saying?
And Mr. Chief Justice, I believe that is because of, if we do something here, I think we're probably reweighing that evidence. And the district court judge had the benefit of evaluating the witnesses and all the evidence, albeit the wrong standard.
Well, I'm referring to what the Court of Appeals concluded in its discussion on any error is harmless, which I believe goes back to Justice Stiegel's question. And among the things that were cited here, won't go over all of them, it says, evidence showed, quote, a myriad of reasons why Roxy would choose to disinherit Harvey, unquote. Evidence showed Roxy was a strong-willed woman who was not easily influenced. No evidence showed Maureen's actions were motivated by greed. No evidence showed Roxy had ever expressed a desire for the home place to go to anyone other than her grandsons. And then the Court of Appeals concludes by saying, Harvey does not raise any challenge to any of these findings of fact, nor does he contend the district court overlooked contrary evidence. Is that last sentence correct?
It is incorrect. We believe that the district court really overlooked contrary evidence, especially at the time of the signing. We would not dispute one iota that she was a very strong-willed, independent woman, but she was not a strong-willed, independent woman when she was 94 years of age in the nursing home lying flat on her back and could not so much as lift an arm to sign her most precious possession, apparently, that being her farm.
All right, thank you. Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.